So, well, I want to call this meeting to order for the ZBA. It's not a special meeting, but being Friday, what's today, the 24th?
Yes.
24th. This is a continuation of an appeal application for Terry Buck and Allison Group, Fairview Avenue. This is being recorded. So, maybe I would ask Ken to give a little bit of a recap. We were dealing with issues, bullet points of appeal at the last meeting, and we have addressed some of these areas, and there were two that we have not, that we were, what's the word? Trying to
There's
decide.
still open questions.
Still open questions about that.
So there's no formal vote because the matter's still open, but of the six issues that were, I'll just read them in order, and it could show up in the form, the decision worksheet. Appealing the determination that the utility pole structure did not require a special use permit, citing sections 11045A and 11045B. That one was left open because the board was not able to make a decision whether or not that the appeal on that question was timely. There was some communications around the end of October, beginning of November, and you were going to evaluate whether that set the clock running on those. Item number 2, which is also appealing the determination that the utility pole was not required to be part of the special use permit review under different sections, 11015E3 and 11015C5. Similarly, because they both had to do with whether you need the special use permit review. The first question is, you're going to try to look more closely at some of the email communications and determine whether or not those were timely. So those are the ones that were open. The remaining, the other 4, we basically did address and reach your answers to, again, without a formal vote. But on the third one, which is about the 25% expansion, we found it was an order of the code enforcement officer, but on 2 grounds. One, that was determined back on August 15th. So one, the appeal to that one was not timely, but secondly, you also noted that you agreed on the merits, that it was 25% based on the expansion of the footprint, the concrete footprint, which was not the fencing area. So both on the timeliness and on the merits of the question, you denied, the view is that appeal on that question should be denied. On number 4, about height variance, was an appeal of was an order of the code enforcement officer. Again, this is one with a date of determination. It was somewhat at issue October 31st. There was a letter, but you did go through the merits on that and viewed that because you look at 11014.8 that lists certain structures, trying to reconcile that with the density control schedule that only applies to buildings and a couple other provisions of the code, and the legal principle that ambiguities have to be construed in favor of the property owner who wants to do something. You reached the view that that the code enforcement officer's determination was proper, and then the 5th one had to do with referring the applicant for a variance in section 11014, which is actually a procedure of the planning board, that as those sections are not determinations of the code enforcement officer, so they weren't subject to review here. And the last one had to do with the notice, which part of the code is the obligation of the landowner. The view was that that was not a determination of the code enforcement officer. And then in addition, the appellants attended all the meetings, and so there was no prejudice for any imperfection in the first place. We rejected that appeal on that question. So you hit the questions that are pending both have to do with whether or not the pole had to be involved, had to be subject to special use permit. And the first part that was unresolved, which you probably take up, is whether or not you feel you can make a determination about the timeliness and whether the appeal of those questions was within the 60 days of the determination. And there was some communication, so you might want to talk about that and figure out where you...
So that's referring to 11045A and B? That's right?
Well, yeah, but the first, before you get to the merits of it, there is the question was left open, which is when was the determination of, when did the code enforcement officer make the determination that the pole did not need to be subject to special use permit review, and in particular, when did the appellants have a reasonable knowledge of that?
Right.
And did they have, and did they file an appeal within 60 days, and when they reasonably should have had knowledge of it, of the note of the decision? So that's the first question, and I know you're having a hard time reaching a clear answer to that, so you may, but that's the threshold, so you should look at that first.
Well, I personally have found this to be really confusing with those dates and all the emails going back and forth and the timing of all of this. I think I do think there's a lot of ambiguity in this, in the timing of when everything was filed. And I'm trying to get past that to the next issue on that particular issue on this, on number one, on the list of problems with it, but I think we need to deal with the time first, whether or not this was or was not filed in a timely manner. And once again, through my notes, I go back and forth with all of these dates that I have. And I'm at a loss, quite frankly. On how to proceed with it. You guys have any research or any determination about it?
Not going any further, no.
Yeah. Lori?
No, I also was a little confused. I mean, I see, like I saw correspondence October 25th.
And then there was an October 10th. But to go over these dates again, it's just, and that's in the stream of emails that were in this packet. Erin, this is in your packet?
Yeah, but after the last meeting, I had sent you the email with the confirmation emails that the determination was verbally made to NYSEG on Tuesday the 28th, because I'm only in the office on Tuesdays and Fridays. I didn't actually draft a letter to the planning board until October 30th, but I have the email that's dated from October 30th that I sent you guys from Allison that says to Carrie Chris, yes, right now I called the village, they told me the pole is going up and doesn't have to be approved since it's just replacing the old one. So they were confirmed knowledge of it on October 30th.
And then moving forward to,
Then there was that November 4th, and then October 31st was the date I drafted the letter to the planning board.
right. So what's the time there? The days, what's the January 5th date? There's a January date in there too.
I think that was the date of,
Filing 60 days.
that was the filing date for their appeal.
Okay,
Right,
so that's
so it has to
more
be
than,
60 days before that.
so that's more than 60 days, yeah.
How much more?
How much more?
Yeah.
From January 5th to October
30.
It's like 4 days,
30th? Yeah,
4 days.
more or less in time, 4 days over. And, you know, I don't know, to me,
Was it a weekend?
I don't know, but I don't think that that's how it runs. I think it's calendar days.
Yeah, no, the 30th was a Friday, so October 30th was a Thursday.
I also wrote like various formal complaints, like from starting like in September. I sent them to you guys, I sent them to the mayor. I mean, there's a paper trail that we have been actively, sending formal complaints. It wasn't until we realized like we weren't getting anywhere that we applied for the ZBA.
Right.
So we have like letters and letters of
But I don't
formal
think that those
complaints.
pertain to it's when it was filed.
Right.
I understand where you're getting at, but in this situation, the date's the date, the time is the time. I wish in a world we could say, yeah, but the situation, I don't think we can. Do you agree with that, Ken, or
Well,
is
the
that?
other question that I think you want to look at is, if you have emails, a particular date, to look at the communications and decide whether those communications inform the elements of the decision. So, if the decision was that the whole didn't need a special use permit, wasn't part of special use permit review, you should look at the question whether you're satisfied that that was communicated in those emails. So look at the content.
Okay, well, let's collect those emails. And do we have a stack of those emails here, or are they in here? They're listed in here, right? In your packet.
And these are the two that were, I think you both have these.
Yes, I have these.
Or excluding like 2 weeks for the holidays, right? Because there was like Thanksgiving and Christmas in there. So that would kind of exclude those weeks, those days.
Maybe not, it's a question of the calendar days versus,
Is calendar days?
It's strict calendar days.
Yeah.
The question, it's
Business
not about
days.
the intervening days, it's a question of whether or not notification of the decision was conveyed to the applicant, so it was made aware of them at least 60 days prior. So it's
Well, it's when we put the application to the ZBA, right?
right.
So we wouldn't have put it in sooner if it wasn't for the holidays. Because I did try to put it in sooner, but I think I missed the date. And then I waited after the holidays and put it in.
That's when the intervening days, unless the actual day that it was supposed to go in, and the intervening days don't have any bearing on this at all, except if the final day, a deadline to do something falls on the Sunday or holiday, then you have the next business day. But if it wasn't an actual Sunday or holiday when the due date, it doesn't happen. There's a lot of law on this. I mean, this stuff's pretty good. It's well settled in here.
So, I think we conclude that it wasn't timely, and,
Well, can you just refer to the part, I would maybe, if that's the case, we should refer to the part of the emails that convey the
yeah, well,
awareness of the,
Well, here,
That's gonna
October
be-
30th, it says it's from Allison. Right now, I called the village, they told me the COLA's going up and doesn't have to be approved, since it's just replacing the old one.
can you show me that one? Why can't I read this? Yeah, down here.
But I just want to see 60 days from.
I don't know how this, particularly the statement decides whether or not they were notified or not. I don't know how to decipher that, whether or not that's,
The 60 days would have been from October 30th, would have been December 29th.
and that's the last, we have anything I see in here is prior to the 30th. We have the 27th, we have one here on the 25th. Do you have that email then there, Ken? This one?
I just gave you that copy.
Yeah, I know. One on the bottom of the page.
Can you just put a line in the part that you're referring to? Just so I know. Thank you. I'll make this up.
Okay. Does that clear that up?
Do you want to address the substance of it at the same time?
Do we want what?
Do you want to address the substance? I mean, if you concluded that it wasn't timely, and if you want to, some of the other ones would also address the underlying question.
Well, the substance of that email you're talking
No,
about?
the question.
Underneath that, yeah.
Like, for example, in the third one, about the 25%, that one you felt, you completely was not timely, but you also went on to say that in addition, we agreed that the 25% of the footprint expansion that CEO used is proper, so you kind of did both.
We did both.
You can do that, and it's not mandatory, if you find it's untimely, but if you want.
Well, to me, if it's untimely, then that's the, if it was untimely and we consider other elements of that point, then is it,
I mean,
does it cancel out that?
no, it
fact that
doesn't.
was
It's untimely,
untimely?
it's untimely. If you determine it's untimely,
Yeah.
that is the end of it.
Yeah.
It's not reviewable.
That's what I would prefer. I think otherwise it gets really
Okay.
complicated to, and if we're talking about calendar and not holiday.
That we're not talking about. I mean, that's not
Yeah.
part of the question, it's just, the question is determining when they were made aware of it, when the determination was made and when they were aware that it was made. And if you judge that that was October 30th, and it was filed on January 5th or 6th,
Right.
that's more than 60 days, and that's just, there's just, what happened in December has no bearing on it.
Okay.
It's only the first day and the last day that.
So what do we cite this email as?
Yeah, and that's what you would have to do.
Yeah.
So emails are the determination? Those are proof of determination?
It's a determination of getting a date as to when things occurred.
But is that the date of the determination? Right, like filed and everything?
I don't know the question.
When it was filed, the
Okay.
determination was, doesn't there have to be an official determination filed? To remove
Well,
something from the,
No, because the pole was never on the plans anyway. It was
yes, it
just-
was.
It was on the plans, but it wasn't ever part of the application.
I remember it.
NICEAG was moving forward and we verbally wrote the letter to the planning board on the October 30th, but the verbal determination was October 28th, that the pole was to go ahead
I mean, it
with
does have
construction.
to, it's correct, it does have to be a written,
Yeah.
Yeah.
a formal thing, but I mean, there's also the letter from the planning board, to the planning board, dated the 31st.
Right, yeah.
Which says, you know, type of the pole, it's within the footprint, it's in the paperwork, but it is not part of the special use permit for the expansion of non-conformance. That was on the 31st. And then
Yeah.
there's the emails as well, making them aware, so.
So, can you use that? It's not the email, I mean, that's a formal,
Yeah,
formal,
the 30th, 31st.
the first. Is that making sense, Ken, or?
Yeah, I mean, I suppose,
Yeah.
you have to make these calls.
Well,
based on your reading
I
things. I mean, that's not my decision.
To me, I feel that that verifies the notification, that's the filing of it. That letter, that email, letter to the planning board. Detail anything from the planning?
That's okay. I think the 31st is reasonable.
Okay.
What I'm not clear about is the nature of the objection that was entered by Allison and whoever else in January. Beyond, if it was beyond that, what is that and why is that crucial rather than some of the other comments that were made? Why are we counting on that date as the crucial one? Is that
Because
the
that's
actual filing?
That is the statutory, that is the New York State law statutory limit that appeals have to be filed.
And the appeal has to be filed,
Has to
it
be
can't be,
filed.
it can't be done in an email, informally, or any other way.
As the appeal to the zoning board of appeals has to be filed with the zoning board within 60 days of the determination being made.
So we're trying to find that.
That's
I
statutory.
get that, I get the time issue, I'm just asking the substance of what involves an appeal. And
Yeah,
that
that's,
appears to be
that
a
is-
formal statement, yes?
I mean, I can refer to you to that, because it is in
So if somebody stands up before the planning board and says, I object to this, that doesn't count because it's not a formal appeal, correct?
That's correct. Yeah, in the code,
Right, I know what you're saying, if it's in an email, if it's written in an email saying I object, is that considered a formal?
no, it's
No.
not. There is a process in here,
Yeah, that was my question, actually.
1065, 11065, appeals procedure. This is under the zoning board of appeals. Appeals procedure. Notice of appeal shall be filed with the building inspector and the secretary to the board in writing in a form required by such board within 60 days of the date that the act been appealed from, specifying the grounds thereof. Upon the filing of the notice of appeal and payment of the required filing fee, it will be transmitted to the board, and then it goes on more details about the proceedings. That's the
Thank you.
beginning.
Okay. The next one was,
It's also a special use permit. It's also a question about the special use permit,
the time,
just under
and
different,
those times are the same, correct? So, when will we, the other issues were dealt with, correct?
yeah.
So there comes a time when we need to make a decision about whether or not this application is going to move forward here. And given the information that I see, I think, how do we formally do this? I don't see that we can grant this appeal. I just don't see it. Whether it's a technicality or whatever it is, it's. So how might we move forward, Ken?
Well, I mean, based on what you included over the last two meetings, points, you determined points 1, 2, 3, and 4 were not filed within 60 days of the date.
Right? So we would have to,
In addition, you did elaborate that on 3 and 4, you also went beyond the timeliness question and upheld the code enforcement's interpretation of those provisions.
calculations for the percentage.
Yeah,
correct?
and the question of height variance based mainly on the ambiguity in the code. And points 5 and 6 determined were not actually actions, they were not actually orders for determinations of code enforcement officers, so they were also reviewed. So that's what you did reach over the last 2 weeks.
So can we put this into a motion? Can we,
Yeah, I can write up
do you-
a summary of it. I think there's some additional details that basically the motion would be to deny
the motion would be to deny the
6 points of the
appeal application.
4 on the basis of timeliness, 2 on the basis that they were not, the last one, basically they were not decisions from the code enforcement officer outside of jurisdiction. And then with a further elaboration, you also found the 34th, you upheld the 34th in addition to timeliness, you upheld the 34th on the merits of the question.
Correct. So can we make a motion based on that? And,
Yeah.
okay, I'd make that motion. Can I get a second?
All right.
All in favor? Opposed? Passes.
Thank you for your time, I appreciate it. Thank you.
Thank you. So you'll write that, you'll compose a, because I know I couldn't do it. And then, And will that happen at your convenience or at
Promptly.
promptly?
It should go right away.
Okay.
I'm gonna try to do it in summary of it, so I'll just write out the 6 things, that 4 of them are on timeliness, and I'll refer to the specific documents. The emails for some, there were a couple others from earlier on in August, and a couple of them, so like I'll just, the decision is what it is, but there'll be a brief memo that supports it with
Supports that.
the documentation, and then the last 2, if they weren't determination.
They weren't determination.
And so it'll be just like a page or something.
Okay.
And I'll
And
CC everybody, I'll send it out to everybody for their review. And I'll just do some of the weekend, so we get it promptly.
Okay.
Because it's contentious.
Well, it is the weekend.
Well, no,
No.
like I said, I mean, when it's something that's contentious, you want to make sure it's done.
No, yeah,
So I'll just
that would
write
be
it up and get it out to you, in the next couple of days.
And then I would come in and sign that officially, or that would be
You could do that, yeah. I mean, I just want the 3 of you to review it and see that
Yeah,
it reflects
yeah.
what you said.
okay.
I mean, the motion is what we just did,
Right.
to just memorialize that.
Right.
I mean, the notification is supposed to go, and boards often don't meet, so I can just send it with your approval, Jennifer can send it out, but I just want,
Yeah, we just need it, and
I just want to make sure that I write it out, and you all see it,
Okey-dokey,
so that
yeah.
that it reflects these points. It's not gonna be very extensive, but I just want to go through the 6 points, what the determination was, reference, because 4 of them had to do with timeliness of communications, like the emails or the documents that were filed, and the other, so it doesn't need to be an elaborate explanation.
Okay. I think it's pretty clear. I think
So
it's
then,
pretty
yeah,
clear.
they're entitled to notification, a written notification of the outcome, so do that promptly.
And that will go out to, Allison and Terry as
Yeah.
well?
Yeah, they're the ones who they're
Yeah.
entitled to the
Okay.
written result of their appeal,
Great.
so.
And what else did you need me to do? Like approve minutes, so you wanted me to?
Yeah, there was several minutes that we haven't approved, so if we could just officially.
This is going back to
approve
February.
January, February, and March, we're all pending still, so.
Well, I've read them all, and I'd make a motion to approve them.
I'll
And
second.
second that, all in favor?
Aye.
Aye. And we can adjourn at 7:30, whatever, I don't think we have to say the time.
Good time.
Thank you all.
They